Welcome to Risk Engineers Talk Governance. In this episode, due diligence engineers Richard Robinson and Gaye Francis discuss the difference between the laws of man and the laws of nature. We hope you enjoy their chat. If you do, please give us a rating and subscribe on your favourite podcast platform. If you have any feedback or topic ideas, we'd love to hear from you. Email us at admin@r2a.com.au.
Good morning, Richard. Welcome back to another podcast session.
Good to be here, Gaye.
Today we're going to talk about the law and the differences in the laws of man, but we also have to relate it back to the laws of nature, which is really where the due diligence aspect comes from, especially for our type of work.
That's right. You've got to, in order to be safe or efficient, or however you want to define it, due diligence means you've got to manage the laws of nature in a way that satisfies the laws of man. And the trick is, of course, the laws of man actually does vary a little bit from place to place, which can be quite confusing. Now, R2A does spend a fair bit of its time within the legal system. It's not something we actually choose to do so much as we get invited to do. So, for example, I spent some time at an expert witness case to the Supreme Court of Sydney with a fellow called John Ages, SC. The judge hadn't read my expert opinion, so I had 2 hours just talking to him about various things, picking his brains, as you do. For example, too, that R2A sponsors the Professor in Law of Public Policy out from Cambridge in 2018, I think it was. Because he had a book out, Law as Engineering, and he was comparing what the lawyers do with what engineers do. And there are some significant parallels between the management of laws of nature and the way in which the laws of man goes about things and does things. So what I thought might just be worth going through and making a few remarks about all this from the point of view of how the way engineers interpret what we've been told. And quite a lot of this is important in the sense that a lot of the principles the lawyers actually enunciate is a logical consequence of how things are done and how they've gone about it. So, for example, and I think we've talked about this before, the way in which the adversarial system arose in the English common law system. It was King Henry II. They'd had a civil war. The kings tried to extend the power of the king with these feudal lords who'd been on one side of the fight or the other before he became or ascended the throne. And so he appointed his own lord judges. And those lord judges took the book of common law and went through each of the fiefdoms, acting as the judge instead of the previous lord. And that means that English law lord had to have the same power and stature as the duke or whoever was in charge of a particular fiefdom was. And what they did was if they found the law that was common 9 out of 10 fiefdoms, then that was the common law which they applied in the 10th. Now this has a number of direct consequences, and you can pretty easily see that if you're a judge that just turned up from London on a circuit, you'd never been to this place before, and some people are having a dispute about something. How do you work it all out? Now, there's a couple of things you do. First of all, you're in charge of the law. Nobody else gets to decide the law. You might have noticed we were sitting around a VCAT tribunal just recently.
Yes.
The lawyers were having the discussion, we will decide the law. And our side was just a young couple and us, right? But when it came to laws of nature, that's when we came to the fore and how they were going to be managed, right? Now, that's the first thing. The system, they hold on to that. The next thing is that you do get this adversarial system because you turn up at a place you've never been before. How does a judge come to a view about what ought to be done? And the answer is, well, the court has a court-appointed representatives, barristers or lawyers, who put forward the case in a way in which the judge can understand, and then they start to stash it out, and then legal argument ensues. But it's meant to be reporting on what actually happened, the events, in some constructive way. But that means those representatives have to become officers of the court. So, and when we're an expert witness, we're actually acting, our first duty is to the court, not to the person who's paying us, which obviously breaks all the codes of ethics of consulting engineers. But that's the way it's done. I mean, I think it only ever happened to me once. The way it's supposed to happen is that when the other side discovers who the expert witness is, they say, oh, good, we won't have to hire ours, we'll rely on them. Doesn't happen very often, but it's very nice when it does.
So you're working for the court and you're giving the information to the court to make an informed decision.
That's correct. Now, it's done on an adversarial basis. Now, this is where it sort of gets kind of curious because I don't know if you've ever got Rumpole and Leo McKern and all those sort of interesting cases, but he always had this thing about the golden thread, innocent until proven guilty, right? Now, innocent until proven guilty, it's not actually a principle in itself, it's just a logical consequence of having an adversarial system. Because when you go to court, the only way you can have a trial is if you plead not guilty or innocent, right? Because if you plead guilty, the trial's over apart from the penalty. So it has to be that way. Now that compares itself to the inquisitorial European Napoleonic Roman law system, where it's inquisitorial. Now if you apply that principle in an inquisitorial system, what are you going to do? Talk to the entire population to find out who's potentially guilty? The only way you can do it in an inquisitorial system is to assume that a certain pool of people are guilty and then keep asking questions until you've figured out which one probably did it.
So you're proving that the others are innocent.
In effect, yes. But they're the consequences of the different process. It's not a special principle in itself. If you choose to have an adversarial system, you must be innocent until proven guilty, or you can't have the argument. Conversely, if you have an inquisitorial system, you must assume that which the guilty pool are and then prove each of them innocent. Now that leads on to Scots law. And I do admire the Scots in this one. I once did a course in Scotland. I was doing London, Leeds and Glasgow a long time ago. And so I turned up in Scotland to give a course, and I didn't realise Scots law was quite so different. You see, in the adversarial system, it's guilty or not guilty. The Scots aren't quite as trusting as that. They have a different opinion. They have three outcomes. The charges can be proven, the charges can be not proven, meaning you can be proven innocent, you can be proven guilty, or the charges can be not proven. Now, I think if you get taken to court and it can be shown beyond reasonable doubt it had nothing to do with you, that's an important finding, right? If the charge is not proven, the Scots reserve the right to give it another bash at a later date if new evidence arises. It seems to me the Scots have a very pragmatic view of the law, which is superior to the English adversarial system, guilty and not guilty, that we
have here in Australia as well.
Yeah. No, I'm all in favour of being given the benefit of the doubt, and the idea that not guilty people could be, basically you've got to be proven guilty beyond reasonable doubt before you'd be put away for a long time, and all those sorts of things. So you get the benefit of the doubt. But I think the Scots have got a much better understanding of what the possible outcomes actually are. And I would have thought, if we were talking about law reform commissions in Australia, consideration to adopting the Scottish model would be something we should think about.
Well, we've talked in a number of other podcasts as well, isn't it? And it's not a justice system per se. It's a governance system that will go through the process. It'll be due process.
Correct.
And so that sort of feeds into that guilty, not
guilty. They do
guilty
not promise
sort of
justice. They promise due process.
Yeah.
Engineers Australia's quote, what is a fact? Is it what actually happened between sensible and smart? Most emphatically not. At best, it's only what the trial court, the trial judge or jury thinks happened. But the trial court, the judge or jury may be hopelessly incorrect, but that doesn't matter legally speaking. I used to think I was in contempt of court for that till I found that happy quote from Engineers Australia. I assume they have good lawyers.
So I think that's one of the interesting things, isn't it? You go on and that would be our experience in some of the court cases that we've been involved in. You have very clever lawyers, and some of the things that are presented are very focused in and targeted in a particular direction.
Well, I better not talk about the case in particular, but I remember doing one in a county court, I think it was. There was a 6-person jury impanelled when I turned up to do my piece, which was a genuine surprise to me, and I couldn't figure out why until I sort of got in there in the afternoon. The different jurisdictions do things in different ways. In Victoria, expert witnesses don't get invited till they're needed, whereas when I've been sitting around the Supreme Court in New South Wales, you get to listen to the whole proceedings. You know exactly what's going on and just how rotten the other opposing barrister may or may not be. But in this instance, I was a bit nonplussed because it wasn't a big matter, and I was surprised to find a jury impanelled. Anyway, what I did was I pulled up my report to talk to it, because in the past what I've discovered is your barrister, and in quotation marks, sort of says, who are you and why might you be an expert, and all these different questions they ask you. And then they make you, what the expression is, read your report into evidence, and they take you through your report to make the key points and things like that. Now, I pulled my report out to getting ready to talk to it in the witness box, and the opposing barrister said, he's going to read from his report. I said, what? And then I got kicked out, the jury got kicked out, and the two barristers going hammer and tongs before the magistrate. A little while later, we get called back in, and I think I worked out what happened. You see, in my report, I had a series of photographs sort of showing what had happened, and I'd gone through the 4 tests of causation, and I said, based on this, my expectation, if this matter goes to court, then I would think that the plaintiff will win the case and the defendant will lose it.
So you put a finding in there.
I put a finding in there. Now, as I sort of discovered, there is a rule that an expert witness is not allowed to lead a jury to a conclusion. And that was a conclusion. Now, if it was just trial by a judge, which is what I was expecting, whether or not I've drawn a conclusion or the judge gives no cognizance of that, they'll listen to my argument and think whether the argument's reasonable in the circumstance and therefore the finding should go one way or the other. But when there's a jury involved, I'm not allowed to do that. So that meant the barrister on my side should have told me to take that out just in case trial by jury happened, but having left it in, if you did have trial by jury, that could not be led in evidence. So the reason why I came to that conclusion was because my photographs were allowed to be submitted to the jury when we all came back inside, and the barrister asked me all the core questions that were in my report, but my report was never entered into evidence.
But didn't ask you that final question. What are your thoughts on what would happen if?
Well, that's correct, because that was not appropriate in front of a jury.
Yeah.
But that means the entire legal system was set up, and my report wasn't helpful to the defence, let's put it that way. So the opposing barrister thought they'd do something clever, impanel the jury and get rid of my report, which didn't seem to work too well for them. But anyway, that cost an awful lot more money, consumed the time and resource of a whole lot of our citizens, but that was the process.
Yeah. So I guess just in wrapping up this podcast, there are different ways that the law can be interpreted and different ways.
Jurisdictions is the
thank
term.
you. So you just have to be mindful of that, but always in our work that we do, you're always managing the laws of nature first, and then in a way that satisfies the laws of man.
Correct.
So credible critical issues, make sure all reasonable practical controls are in place.
Indeed.
Thanks for joining us again, Richard, and we'll see everyone next time.